So it's my great pleasure to introduce Professor Tan Boston. Professor Boston is an assistant professor of law at Northern Kentucky University, where she teaches property and sports law. She's had a long career. So she did got her JD from the University of Virginia School of Law, then got her first dream job with the NCAA, and her career there included stints in governance and the general counsel departments at the NCAA. After that, she moved into a more private space, working for Wyndham as an attorney for several years before going to Dayton, where she got her LLM degree, and then became the director of their Masters of Studies in Law and LLM programs for a few years before doing some various visiting assistant professorships and finally joining the University of Northern Kentucky as a tenure track assistant professor of law. Now, Professor Boston specializes, and she's starting to build her focus in sports law, particularly areas of name, image, and likeness, Title IX, and related intersectional areas of that law. So she's been publishing a few different articles in that space. She's published recently in the Louisiana Law Review, Richmond Law Review, and Stanford Journal of Civil Rights and Civil Liberties. And her career is just beginning. So you're going to get to say, I saw Professor Boston at Iowa when she was in her first year of law teaching. So with that, it's my great pleasure to introduce Professor Tan Boston, who's going to be talking about the NIL glass ceiling.
Thank you so much. Thank you so much for that wonderful introduction. And again, thank you all for attending when you've got, such a strong competitor somewhere else. I really appreciate you being here. As you've already heard, I'm relatively new to teaching, and so you guys are going to get my inaugural NIL glass ceiling presentation, which I hope you enjoy very much. This is an area that, I enjoy. I enjoy teaching, of course, but I'm always been very passionate about the legal aspects of intercollegiate athletics, and it's just been a great opportunity for me to blend my passions with my career. So thank you all again for joining me, because this is probably going to be more enjoyable for me than it is for you guys. So let's get right into it. We are going to talk about Title IX as it relates to NIL. I know typically when you guys hear about NIL, which you'll hear me say NIL, you'll hear me say NIL, you'll hear me say name, image, and likeness. That's all the same thing. So I'm going to switch back and forth occasionally between those three terms, but just know that I'm talking about the same thing. And so today we're going to talk about NIL in terms of the impact that it's having on women's sports and women's teams. But before we get there, I'm just going to assume that not all of you are familiar with Title IX and the intricacies of it. So I'm going to give you a short primer on that. And then we'll do I know you guys probably do know NIL very well, but I'll do a brief overview of that as well before I get into how the two merge and relate in my world. So let's get started. Brief overview of what I'll talk about. I just told you guys that we'll do our overview, then we'll talk about NIL a little bit more. But let's start with Title IX. What is Title IX? How many of you, by a show of hands, are familiar with Title IX already? Because I don't want to go into too much detail if you guys are. All right, so that's great. That is excellent. So I will definitely do a brief overview. So Title IX is very short, as you know. And at the time, when Title IX was being debated in Congress, it was very controversial. Ultimately, it did get passed, but as you can see, it's very short. And when you have a statute that's this short, of course, it's going to require some regulation. So you can see it there on the screen. Most of the time when you see this quoted, you're going to see that these are 37 words, but no. The editors at the University of Richmond Law Review told me, no, actually it's 39. And so that's what they're going with. So you can see it here on the screen. No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. And so when we talk about that, when you're thinking of suing on the basis of a Title IX claim, which I have heard rumors that there may have been some lawsuits at some point at this university regarding that. these are the typical things that you're going to want to prove. You know that there's an educational program or activity. Clearly, it's met here that the program receives federal financial assistance. And it's important to note that the program itself, for example, most athletic departments don't directly receive federal financial assistance. But as you guys know, I'm sure if there's any department within the school that receives federal financial assistance, all of the departments within that school are going to be subject to Title IX. So that's a key thing to remember. And then we know that it has to be, discrimination on the basis of sex. And another reason that this part of the presentation is important, if you guys have been following, the news cycle lately, you might have heard that President Joe Biden just came out with additional regulations surrounding transgender athletes. And so we've seen, across the nation, lots of states passing legislation banning transgender athletes from participating in intercollegiate athletics. We know that that categorical ban isn't going to hold up under President Biden's new rules on that. But one thing that may become an issue is the definition of sex. So as we go forward and kind of explore whether the new statements are going to be upheld in courts, that term sex is going to, be at issue here. Does it include gender identity and all such as that? So that isn't the crux of my presentation, but I just thought I'd mention it since it was just so recently in the news cycle. So here, back to our topic at hand, Title IX and intercollegiate athletics. Those of you that have studied this area, you know that there's three main categories for compliance when we're talking about athletics. And before NIL, these three categories pretty much were sufficient to cover everything, as it related to intercollegiate athletics and sports and sex discrimination. So we've got the athletic scholarship category, benefits and services, which includes things such as, recruiting, equipment, tutoring, coaches, all of those various housing, all of those various different benefits that student athletes receive. And then we've got this third category, effective accommodation of students' interests and abilities. And when we're talking about that, we're, essentially talking about the claims regarding the University of Iowa lawsuit. So typically when you have student athletes suing because that teams have been eliminated, this is the prong or this is the category of compliance that they're focusing in on. One thing that I did want to note, and this is another aside, schools have, very broad flexibility when they're talking or considering eliminating teams for financial reasons. One option, they could, eliminate some teams in order to ensure that gender equity remains the same or in compliance with Title IX. They could eliminate teams, but another thing that they can do is add teams. But typically schools are eliminating teams due to financial and budget constraints. So a consideration that they definitely need to consider is, are they already in compliance with Title IX? And if they are, how is the elimination or reduction of teams going to impact that? And if they're not, they definitely don't want to be, further out of compliance with their elimination of teams. So when we're talking about NIL, we tend to be talking about benefits and services. Those other two categories aren't as applicable, but there is a little bit of overlap with scholarships, as we'll see later in the presentation. So how does Title IX work? This is where I bring in my professorship here. All right, I've got a question for you. I've got a hypothetical there for you on the screen. So it says the members of state use women's teams sell candy bars and hold bake sales to pay for travel to games. The men's teams travel by chartered bus at the university expense. Call of the question, this is a Title IX violation, true or false? Who would like to assist me with this hypothetical? Is this a Title IX violation? Yes.
I would feel like it's true that it is a Title IX violation.
Why?
You see a unequal distribution of university funding. The men's team to get their travel paid for, while the women's team receives none from the university.
Excellent. All right, so to go a little bit deeper, so there's this 1979 policy interpretation that kind of goes hand in hand with our Title IX statute, and you are correct. It says, benefits must be equivalent in kind equality or availability, if I could say it correctly, or availability for male and female athletes. And so here, because we've got, oh my goodness, when I did this hypothetical in class, I just could not stop laughing. And I know it's not funny because that was an example that was ripped from the headlines where, the women's teams had to do bake sales and other different activities, whereas the men's teams had their travel and things such as that funded by the university. So it's definitely not funny, but within the context of, today we think of, oh my goodness, that's so egregious. But that was actually a true hypothetical at one point in time. Hopefully we don't have schools still doing that. All right, so now we're gonna get into NIL. So what is NIL? I know you all know this. So what do you guys think of when you think about NIL? What is it? What's the first thing you think about? I think of social media first now these days. So I just got a brief overview here. It's any activity that involves the use of an individual's name, image, or likeness for commercial or promotional purposes. And social media seems to be where the student athletes are really cleaning up these days. And so that's the first thing that comes to mind for me. Of course, there's others, there's student athletes that are doing birthday parties. So you book your favorite student athlete to come to your child or your birthday party or your birthday party, right? So there's lots of different ways that student athletes can now monetize their NIL. So do we have any student athletes in the room? Any student athletes in the room? Or former student athletes in the room? Well, in the sports law class that I'm teaching, I had an active student athlete. So she was a graduate of the university, and she had one more year of eligibility because of COVID. And so she was still actively participating in the softball team while she was taking law school classes. And that was completely amazing to me. So I don't think she maximized her NIL in the one season that she had left, but she could have. All right. So how does it work? So I like to talk about the different types of NIL because this is really important because we certainly have transformed from what was intended with NIL to where we are now. So initially, when the NCAA and the states were contemplating allowing name, image, likeness compensation for student athletes, they initially envisioned it as a process whereby athletes would go to, say, their local car dealership and try to negotiate sponsorships on their own or with their agents if they're one of the more elite athletes, so to speak. So that was what was envisioned, that the athletes or their agents would be doing most of these things on their own. And so we wouldn't have a need for school involvement because allegedly it would be a completely independent activity by student athletes. Enter BYU with their football walk-on team deal that they had. And so that's when we started to kind of morph into the school-facilitated NIL, where we've got schools actively participating in these types of deals. And for those of you that are unfamiliar with the BYU situation, in the very early days of NIL, when Utah did not have an NIL statute, there was this wonderful former booster that decided that now that NIL was a possibility, he wanted to make it possible for every football player to be on a full tuition scholarship. And so that was problematic for a couple of reasons, because at that point in time, schools weren't supposed to be as involved. And also because the NCAA has, limits on the scholarships for particular teams. And if you are allowing walk-ons to also receive a full tuition scholarship, that could potentially, run afoul of the scholarship limits for NCAA purposes. And so we know now that these school facilitated transactions have kind of expanded, and even still the NCAA has allowed that and made some updates to their rules, which we're going to talk about a little bit later. And then we've got the third party facilitated NIL, which is, all the rage these days, the exchanges. Hopefully you guys have heard of those. They're like, the dating sites for athletes and the sponsors, where, athletes can put their profile up on these exchanges, and interested companies or individuals and can connect with the athletes that way. So Open Doors and Influencer are the two big ones that you probably already heard of. Boosters have been around since time immemorial. I'm pretty sure you're familiar with those, and collectives. So collectives have exploded, over the past year, and there's so many now. There's over the last count. I know there was probably 102 the last time I actually counted. I'm sure there's many more now. All right, so here's some examples of the types of figures, dollar figures that we're seeing with these NIL deals. On the female side, we see Livy Dunn kind of dominating in that space on the female side, in addition to the Cavender twins, who got in a little bit of trouble recently with the NCAA. And then you see the men's. Hopefully, by looking at this slide, you see the stark contrast between the headlining NIL deals for men and women. You see here that Bronny James is upwards of $10 million. You see here, I know you guys have followed, hopefully, that Jaden Rashada deal that fell through. That was wow, those numbers were mind-blowing. So you see that there. So you can kind of see the stark difference. Again, some of these articles, I know the Cavender twins are doing a lot better now with that, now that they're at Miami. But the thing that I wanted to point out is if you look at the distribution of name, image, likeness, compensation by sport, something stands out, right? Even in the headlines, you can see this if you didn't have the data here. And so I pulled this data from a report from Open Doors, and it kind of breaks down the NIL compensation by sport. And you can see there that football is receiving the vast majority of it. Men's basketball is coming in second, and then we will have, women's basketball and all other sports fitting into this 17.4% here. And since we know that football is primarily, football is essentially a male sport, we can begin to see, the gender divide right here with this graph. Another resource that you can follow to see how men's and women's NIL is diverging is this On3 website. And typically when I see the valuations or the deals related to NIL for intercollegiate athletes, this site is mentioned. And so this is a site that you guys can go to, and it'll show you, the top 100 NIL valuations for college players. And so you see number 1, Bronny James, and then you see Livy Dunn at number 3. And then drop down a bit for the next female athlete that you see in the top 100, Suni Lee, also a gymnast. And then you'll drop down even further to see number 3 and 4. You've got Haley and Hannah Cavender. But within this list, what the stark contrast is you're going to see, tremendously more male athletes on this top 100 list than you will see female athletes. So we can kind of see the gender divide forming in the data used to support that. So now let's talk about how NIL is regulated. At this point, 32 states have either, some of them still have NIL legislation pending, but you can see that 32 states now have either an executive order or a statute that addresses NIL. So what types of things can we expect to see? California, as I'm sure you're familiar, was the first state to pass legislation that would allow student athletes to earn compensation for their names, images, and likenesses. But Florida beat them as far as the effective date. And so then we had that cascading effect where we saw states kind of rushing to pass their NIL legislation and also coincide with the date in which Florida's legislation was going to be coincide with the date that Florida's legislation was going to become effective, and that was going to be on July 1st of 2021. And so we see that the gist of those statutes are allowing student athletes to receive NIL compensation, and another important thing is that they can also use agents. Disclosure as well is another important aspect. So the NCAA is also a regulator of this, and they came out with, different major statements on NIL. The first one was allowing it, after they had opposed it for so long. The second one was ensuring that everyone knew that NIL collectives were boosters too and should be treated accordingly and restricted accordingly. And then the third statement was on October 26th, and that was the most recent one that's allowing schools to become a lot more involved in NIL. So there's still some restrictions on the things that they can and can't do But the NCAA was kind of backing away from that completely hands-off approach that they had initially took with that June 30th interim NIL policy. So now schools can provide NIL education. They also can connect athletes with collectives. What they cannot do is negotiate contracts. They cannot be a principal in an NIL collective, as well as several other restrictions. One thing we don't see, though, regarding NIL regulation is Title IX. So that's why you say this section is blank. So now we've got one more quiz for you guys. So actually 2 more. So true or false? The assistant football coach at State U subscribes to one of the NIL collectives that provides NIL opportunities for all of State U's athletes. This is an NCAA violation. True or false? Like to volunteer. I certainly don't want to call on anyone, but I will. Let's see. What's your name?
Me?
Yes.
Nora.
Nora, would you like to take a crack at this question?
I want to say it's true.
Let's see. What do we think? All right. Yes, you're right. You are right. So the October, and you can see there the updated NCAA guidance from October says school staff, they can't subscribe to or donate to an NIL collective. They also can't start an NIL collective and various other things that they can't do. But there's a lot more things that they can do now under this most recent guidance. All right, got one more here. The assistant football coach at State U subscribes to one of the NIL collectives that provides NIL opportunities for only State U's football players. This is a Title IX violation. Laura, you want to go ahead? You're doing great here. Keep going.
This one's a little trickier. I'm not sure.
Okay. No one's sure. So you're right. Correct again. No one's sure. We're not sure because as of today, Title IX doesn't really address NIL. So we can venture to guess, and I've ventured to guess in some of my writings that some of you may be familiar with. But as far as Title IX authoritatively stating that it does apply to NIL, we don't know that just yet. In my paper, the NIL glass ceiling, I do try to work through how Title IX does apply to NIL. But again, this isn't a statement that came out from the U.S. Department of Education, although, you might be there at some point, because especially now that the NCAA is allowing schools to be actively involved in these deals, in addition to the fact that we know that they were already probably actively involved in these deals, we have a closer connection to that educational institution piece that we see when we as an element that we need to prove when we have a Title IX claim. And so the thesis essentially of my paper is that if a school is involved in facilitating NIL, whether it's directly or through third-party collectives or any other unique vehicle that they might come up with to try to distance themselves from what's going on, those activities are going to be governed by Title IX. So how do I get there? We know for sure that most schools aren't operating at arm's length with their collectives, and if they're involved in NIL themselves directly, we have a direct line between the educational institutions and NIL. But how do we fit that within the framework of Title IX? We do that because NIL fits more appropriately within the benefits and services category than it does within the scholarships area or the effective accommodations area that we talked about earlier. You can see, those of you that are familiar with Title IX and what we call the laundry list, it has recruiting and publicity on it. We know now that schools have been using NIL to recruit student athletes, whether the NCAA's rules say that that is no good or not. That is essentially what schools are doing. publicity. We know that NIL is kind of a feedback loop, right? So if schools are providing their athletes with publicity, they're getting more NIL deals as a result of it. You know, the NIL deals are providing them with more publicity, which provides them with more publicity. And so it's just an endless cycle. And we can see that, those of you that follow the Sedona Prince saga of the women's basketball tournament, no one had heard of her before that. And then after that tournament, you know, she's getting NIL deals and all these various other opportunities because of the publicity and exposure that she received from making that video. So we know from one of our hypotheticals that if we have benefits and services, they have to be equal or equal in effect for both male and female athletes. So we've already talked about the connection of NIL to the schools. We've already talked about the connection under Title IX of NIL to recruiting and publicity. And therefore, it kind of leads us to the conclusion that, you know, now that schools are allowed to be involved in this, they're also allowed to interact with the collectives, the natural conclusion to this saga is going to be that ultimately we have a direct line to Title IX and NIL, and at some point, perhaps we might see some regulation surrounding that. So what are we going to do once we see that? Because if we determine that Title IX applies to NIL, we also have to have a way to measure compliance, right? And so that's what my next few slides are talking about. How are we going to measure it? Is it going to be a situation where we're going to have an equal split? If you've got, you know, $50 going to the men's, regardless of the number of student athletes that are in the men's programs, do we also have to have, you know, $50? And this might oversimplify it. I know you guys didn't come to law school to do math, so I really wanted to keep it really simple. So our total budget is $100. And if we have an absolute equality as a standard for measuring gender equity under Title IX for NIL, we'd have to provide, you know, $50 for the men's program, $50 for the women's program, regardless of the number of student athletes in them. The second option for measuring compliance could be essentially what we have now, right? Equal access. So schools aren't allowed under the laws or under NCAA policies to prohibit student athletes from pursuing that. So whatever the market says, and right now it's looking like, you know, women are receiving approximately, you know, 1/4 of what the men are receiving from NIL. So if we decide to go with the status quo for measuring compliance, and you know, that's interesting. All right, and then we've got another way. So I'm bringing back scholarships here because this is how compliance for scholarships is determined. And so there's a proportionate equality standard that's already in place for scholarships. So if you've got, you know, 6 women within the whole entire athletic department, you would, and the budget again is $100. You know, you would expect to provide all 6 of those women with $10 each. And if you only had 4 men, they would also, you know, receive $10 each out of the scholarship budget. And so this is a similar way that we could approach NIL if we were trying to determine compliance. And my opinion is that, you know, this is something that's familiar to Title IX. This would be a natural, you know, fit for NIL since it's, you know, can be measured in dollars. And this is my last slide before questions. So I did want to leave time for questions. I know I have until 1:25. So if there are any questions, I'd be happy to answer at this moment, or just thoughts. Maybe you just have thoughts or comments.
I have a question first, and maybe another one. So I'm not totally familiar with like all the Title IX details, but seeing the text of it, it just says that they're not allowed to discriminate based on sex. But then over the years, that has been interpreted to mean equal or equal in effect. Is that right?
So there's, you know, Title IX is very short. So there have been regulations and also policy interpretations. And the policy interpretations is where we find that equal or equal in effect language. So yes, it has kind of, you know, changed from, you know, an anti-discrimination statute to more of an equity or, yes, you're right.
Okay. And then I had a question there at the end, kind of on those different compliance scenarios. And how is this different, like NIL money, and then say scholarships, where the scholarships are coming from the university,
Right.
whereas NIL money is generally not coming from the university, it's coming from
Third parties.
outside.
You are right. You are right.
How would this still kind of work in that same model?
Yes. So that's such an excellent question. One of the rules of the NCAA, it makes schools responsible for what boosters do. So that's one way that schools are connected. Another way is through the court system. And so there are some cases that have held that if schools have boosters that are funding male teams substantially more than female team, schools will be responsible for that inequity. And so there's precedent for holding schools responsible for what's going on with these collectives, especially since we know that the schools are involved with them. The NCAA is also allowing them to be involved, and there's some states now passing legislation amending their NIL laws to say, hey, schools, you can be involved with the collectives or be involved in NIL in any way that you see fit. And so I think that's, a natural extension of, applying Title IX and connecting the schools to the alleged third-party arrangements. Because especially if we think about the Jaden Rashada deal, do you really think that schools are not involved in a deal that is $13 million for one athlete, right? And so it's kind of, the connection was there before, but now that the laws are changing and the NCAA policies are changing, I think we could see a closer connection between the schools and those third parties, and that's where Title IX will come into play. Excellent question.
I was wondering if you could talk a little bit about the penalty. So if there is a Title IX violation under, forgetting how we get there, but what would the penalty be?
Right, and so the ultimate price that schools are supposed to be paying for being out of compliance with Title IX is having their federal funding pulled. We've never seen that actually happen. Not that it never will, but that's the ultimate, penalty that's been waived before. I don't know if we'll see something different for NIL though. There can be different penalties. I'm not sure.
Would it be injunctive, or would it be just like pulling up the funding?
I mean, it could.
Only mechanism.
Right, so it could be injunctive as well. When we see Title IX violations with schools right now, they tend to work out a deal before it gets to that point because the penalty is severe. But it doesn't, that doesn't have to be the penalty.
Sorry, I find this really interesting. I'm going to ask one last.
No, you're fine.
Question. Because just going back, and I'm not at all terribly knowledgeable about this field. You said in the beginning, any school that gets any federal funding, right? Mm-hmm. So, your program in anthropology gets federal funding. Then wouldn't the penalty be bearing down on an unrelated department?
You're right. It is a very severe, I know some law schools have, that doesn't quite, here we go. It's just like some law schools have some very severe penalties for certain types of things that are in violation of their code of conduct. The penalty for Title IX violation is very severe because you're right, it would punish essentially, the whole institution for the acts of us.
Or even people who have nothing to do with it, and not penalizing people who do have something to do with it.
Right. Well, so just to take a step back, so a lot of student athletes are also receiving, federal financial funds as well. So it wouldn't be, completely punishing departments that are external to that. But yeah, you're right. It could hypothetically. You're right.
Could you say a few words about whether you see student athletes becoming employees of the institutions and the implications of that perhaps on NIL?
Sure. So we've seen recently that the NLRB has come out with a declaration that an opinion that student athletes are actually, employees of their institutions. And I think how NIL kind of plays into that is we're seeing, very large numbers. We're moving away from amateurism and into something else. We're not sure exactly what it is, but it looks more like an employment situation than it does like a volunteer situation. And so I think that, ultimately we may get to a point where, and I have no opinion on whether this is good or bad, but ultimately we may get to a point where at least certain student athletes are going to qualify, as employees based on the NIL, based on the hours that they're putting in, based on the billions of dollars that are being earned from, their efforts. So I think we are trending in that area. We've got a case that's pending right now, Johnson, that will give us the case that we need to get to the Supreme Court potentially. So it'll be really interesting to see where this goes. It's, I struggle with it, whether it's the right thing to do given the implications, right? There's implications to NIL as well. So we formerly had donors giving money for perhaps buildings and whole programs. And now, considering that funds aren't typically unlimited, perhaps some of that funding is now going somewhere else. So there's implications to all of this. They're way above my pay grade. So I really kind of waver back and forth on the employment situation because it's going to be, tremendously costly in addition to a lot of other things.
I'm thinking back to penalties for lack of compliance, and I can't skip past in my head when we're thinking about third-party involvement, that there's ultimately going to be so much that an institution can't control that third party. And if they've reached the extent of their control, yet we still have a lack of compliance, could we get to a situation of similar to kind of having federal funds being pulled, that the institution now needs to make up the difference that is being created by these third parties?
Right. And so that's another option for schools that find themselves in a situation where they can't control, they can't influence the party that's providing all of these massive funds to the football team. That's certainly an option as well. I know that there have been some rulings on that where if the school isn't able to make up the difference through other donors or other activities, ultimately they're going to be held responsible. And if they are able and willing to come into compliance in that way by using institutional, that's certainly a way to achieve.
This kind of goes off the, the employment question. I find collectives incredibly fascinating. You have ones like University of Southern California's and Michigan's where they provide a base salary to some of their athletes. Do you view collectives as possibly being a tool to achieve a little more equity for women's sports as a way for them to sort of collectivize and hopefully get them on an equal playing field? Like, what's the role of collectives in bringing possibly more Title IX compliance?
Right. And so, if collectives were not operating the same way that athletics departments had operated for years, I initially thought it would be a great opportunity for women's sports because, as we saw from the most recent basketball tournament, there's lots of interest in women's sports. So there's tremendous potential there for collectives to assist with gender equity under Title IX. Do I think that's where we will get without some outside intervention? I'm not thinking that's going to be the case, but I think there's a tremendous role that they can play. And we have seen some collectives forming for women's sports that are providing, a certain baseline level of NIL. We just haven't seen as many as we have on the men's side, unfortunately. But I think that's a great point.
Do you think that that institutions should play more of a role in providing safety and security for some of these athletes, especially some of the female athletes that are high profile, that are getting big NIL contracts and could easily become victims of stalkers and such?
Right, that's another downside of NIL. So I'm going to address the first part of your question, regarding the safety aspects. I think that's another reason why we may be trending towards, the employment situation. Because when the employment situation comes, those types of benefits, workers' compensation and a plethora of other benefits that are provided to similarly situated employees. And in regards to your question about protecting the student athletes from stalking, I think that's a difficult question because, NIL is going to bring both wanted attention and unwanted attention. And gosh, I'm not sure, other than education and training regarding, things that are going to, that you're going to need to do to protect yourselves from those types of activities. I'm not sure what a school can do from the stalking standpoint. other than providing the education. And maybe if we get to a point where they're employee security. No, just kidding.
Yeah, so I'm wondering about the kind of the control piece of it over these collectives. Does it matter for purposes of compliance with Title IX? And again, I recognize like nothing of this is settled, but in your view, does it matter whether the school has some kind of involvement with the collective, whether the school is like really, really involved with the collective, or where the school is like, we don't want anything to do with this collective, right? We're disavowing anything that the collective does. And is it different from totally third-party situations like were originally envisioned, where the person, the athlete, would go to the car dealership and negotiate on their own? Is that yet another situation?
Yes, and so I think if we want to be in a situation where Title IX does not apply to the schools, we need to get back to what was envisioned with NIL initially, which was that the student athletes were going to be negotiating their own deals, that self-facilitated category. That kind of gets us out of, Title IX, because it only applies to educational institutions. If they are completely divorced from the process, then I don't think we have a Title IX issue at all. If the only thing that they're doing are, collecting those disclosure forms and, training the student athletes on what the NCAA's rules are regarding that, I think that's different from, having the coach set up meetings for players with the collectives, or having the coach make appearances on behalf of the collectives. I think that's, very different. But back to your question, if the school really is independent and has disavowed their $60 million collective and they don't want anything to do with it, then I don't think we have a Title IX problem at all.
This is a little bit broader than just Title IX compliance and kind of the issues in equity that we're starting to see. I'm curious, from your place as a scholar in this area, where you see potential other ramifications happening. And particularly, I'm thinking about, we've now very much professionalized, argue, student athletes, and we're seeing these deals for students that just came out of high school. Is that now going to start trickling into student athletics at the secondary level? So I'm just curious, where you see the downstream effects of some of this.
Right. I think it already has for some in some states. I know some states are now addressing NIL at the high school level, and and sooner. And it's such a slippery slope. And it's a very interesting question. But I think we're already there regarding the high school athletes. They're looking forward. They're training themselves up. The coaches are looking forward. I don't see. I don't see it stopping at college. Versus itself as far back as the regulations allow.
If we were to get to a point where college athletes could be considered employees, and then suddenly we get into a pay-for-play system directly from the universities, what will be the ramifications for women's sports? I know in a lot of universities, football and basketball pay for their budgets for pretty much every other sport, all their Olympic-style sports and women's sports and stuff like that. So if we were to enter a system like that, do you think women's sports at the college level could survive?
They will have to, and the reason they will have to is because of Title IX. And so, at least theoretically, you could say that if we get into a situation where all the student athletes have to be paid, of course, the salary aspect is going to be huge. Salary has to be, equitable under Title IX. The benefits that come along with being an employee have to be equitable as well. But what cannot happen is that because of these increased costs, schools are going to now eliminate all of the women's teams because they're not earning as much revenue for the schools as the men's team. So that's what Title IX was designed to prevent. And yes, there will be some reductions, inevitably, but I don't think it will be a situation where, we're hoping it won't be a situation where schools do not have good counsel and are deciding that they're going to eliminate the non-revenue teams that just happen to be women's teams because of the employment situation.
Secondary question off of that, then, if we were to have a status where student athletes are now employees, would Title IX apply, or like federal like employment anti-discrimination laws apply?
So that's going to apply as well, but because we're within an educational institution and because they are students still, right, we're going to have some Title IX implications to that, regardless of whether they're employee status in employee status or not. Because there's still an educational piece to why they're at the school.
Thank you all so much.
Oh, yes. So many questions. Thank you so much. I'm happy to answer questions afterwards, but I think I'm over time.